Given these changes to the marketplace, now seems like a good time to revisit some of the rules the TCPA put in place. The thrust of the TCPA was to help protect consumers from unwanted telemarketing calls. The question now, however, is whether the TCPA is inadvertently preventing consumers from the convenience of getting other information that consumers do want, and while they're on the go with their mobile phones. And if so, how can we address that? Does the TCPA prevent consumers from receiving informational calls from their banks like fraud or low balance alerts? Do the strictures of the TCPA and the FCC's implementation of it make it too difficult for businesses to engage their customers and provide them with valuable services? What's the proper role for states in protecting the privacy of telephone subscribers? Reasonable people can disagree on the answers to all of these questions, and I imagine we will, but I think we can all agree that any legislation should not subject consumers to unwanted telephone solicitations. Surely we can figure out a way to allow consumers to receive useful informational calls without unleashing the telemarketers. I think that's exactly the needle that this legislation is aiming to thread. We have before us several experts that will help us explore these issues, and I hope we'll learn something about the consumer benefits of mobile informational calls, something about the concerns of consumer advocates and our state's attorneys general, and something about today's wireless marketplace. I think this can be a very productive discussion about ways to improve our country's laws for the benefit of all Americans, and I expect we'll have some vigorous debate on how to do that. That's what hearings are all about. And I thank, again, our colleagues who have brought this legislation forward, and I would now yield to, well, we didn't start the clock, so I don't know how much time I have to yield. Looks like I've got 89 minutes and 43 seconds to, since there was no objection from my, yeah. I would yield to my colleague from Tennessee, Ms. Blackburn, the remaining 1 minute I apparently had. So.
Thank you, Mr. Chairman, and that's about all I need. I do want to let you all know that I appreciate so much your work and Mr. Terry's work, the work of our staff on the Mobile Informational Call Act. I'm a co-sponsor of this, and I think it does strike a reasonable balance that protects consumers while also allowing companies to provide beneficial information. An example of that, when FedEx, one of our Tennessee constituent companies, is able to provide automated informational calls to their customers using cell phones about future deliveries, they're able to increase their delivery rates on a first attempt by as much as 30%. That's a good thing because it reduces cost, helps the customers, and makes things more efficient. Under current law, FedEx is restricted in its ability to make automated calls about deliveries to customers, and we need a common sense way to fix this. Appreciate your good work, and yield back.
I thank the gentlelady, and all times expired on our side. The opening round. Turn now to my ranking member and friend, Ms. Eshoo from California, for 89.5 minutes.
Thank you, Mr. Chairman, and good morning, everyone. Good morning to the witnesses, and thank you for being here. Today's hearing revisits legislation enacted by this committee 20 years ago. Much has changed, as the chairman said, since that time, particularly in the way Americans communicate with each other. An increasing number of U.S. consumers identify their wireless device as their primary means of communication, and many have eliminated the use of a landline phone altogether. And while I believe these changes in consumer behavior warrant our review of the Telephone Consumer Protection Act, I'm concerned about the potential for misuse by modifying the Act. In fact, my constituents have spoken very clearly. They don't like this bill. I've heard from many, many constituents, and to a person, they don't like it. They've written to me since this legislation was introduced, and as I said, they're opposed because they have a lot of concerns about it. We almost always have our wireless devices with us, and I agree that with a consumer's consent, these devices can serve as an ideal method for communicating data breaches, fraud alerts, drug recalls, and other important information in a timely manner. But consent is a very important term. I'm concerned that in redefining, quote, prior express consent, as this legislation does, consumers will unknowingly be opening themselves up to future robocalls anytime they provide a business with their mobile number. Furthermore, unlike landline phones, there's still a cost associated with receiving an incoming call or text message on a wireless device. While it's true that many consumers subscribe to a monthly service plan, there's still a growing portion of the population, particularly many low-income Americans, who rely on prepaid service and pay on a per-minute or per-message basis. We see what happened with the banks and their debit card fees. And I think that there are going to be a lot of consumers in the country, if this bill were adopted in its present form. I think the Congress will hear from an awful lot of people on this. Why should a consumer be subjected to an unsolicited text message at a cost of 20 cents per message? Many consumers may wish to opt out of receiving these informational text messages, preferring instead to receive a phone call, an email, or other form of communication. So these options should be available to consumers, yet they're not considered by this legislation. So I think that there are some real questions that need to be answered about the legislation under consideration. I thank each one of the witnesses for being here with us today, and I look forward to their testimony. And Mr. Chairman, I'd like to ask unanimous consent to submit the following letters of opposition for the record, and I'd like to yield the remaining time that I have to Mr. Doyle for the balance of the time.
Without objection.
Thank you.
I want to thank our ranking member and my good friend Dan Ashew for giving me some time to speak. I want to thank our distinguished panel of witnesses for joining us today. Mr. Chairman, only 4 years ago, I remember the Energy and Commerce Committee's consideration of my bill to make the Do Not Call list permanent. That legislation, which was signed into law in 2008, allows people to opt out of receiving unwanted telemarketing calls once and for all. The bill before the subcommittee today presents a similar opportunity for us to weigh the potential benefits of a business's ability to contact its customers with the importance of consumer protections. As a growing number of people cut the cord in favor of wireless phone and text services, it is commendable that the subcommittee seeks to explore the effects of these changes on the conduct of commerce. However, my initial read of this legislation causes me to worry that its possible harmful impact on consumer welfare could overshadow its benevolent goals. I'm concerned about the bill's potential consequences for individual privacy, as well as its implication on consumers' pocketbooks. So I look forward to learning more from our witnesses about the legislation's impact on consumers in addition to businesses. I want to thank you again to all the members of our panel for taking the time to help explain these complex issues to the subcommittee. Mr. Chairman, I appreciate your patience, and I yield back.
The gentleman yields back his time and now recognize the Vice Chair of the committee, Mr. Terry.
Thank you, Mr. Walden, for holding this hearing today. And this is a continuation of this committee's effort to look at older laws and see how they need to be changed to meet modern needs and technologies. Now, I will admit that after reading some articles that have been written about this, that maybe there's a misperception, but also the misperception can be reality in the sense that the essence of this bill is to ride the fine line between unwanted and wanted communications from people that choose to have the communication occur. So that's the fine line that we're trying to ride here. I make no pretense here that we have perfect language in finding that line, and that's why I'm pleased that all of our panelists are here to help us refine the language today. So, under current law, if a consumer like me gives my cell phone number as my contact to an organization or business, let's say schools, already current in law is I have consented because I physically gave them that phone number. I wrote it down on the line that says, how do we contact you? Okay? Under the FCC, that's permission. The issue is whether the phone number is going to be physically dialed by somebody pushing 10 buttons or whether it is an automated computer-based call. And we think that needs to be modernized. That's where the line should be drawn between weeding out or preventing, and this bill's intent is to never allow an unsolicited, unwanted call. That is the goal here. Now, you look at society today, and it's ubiquitous in our ability to communicate with each other. I give my school my cell phone number. I get texts when there is an emergency or some issue that they need to communicate with. Last year it was a certain virus that was going around the schools. We have snow days in Nebraska. I want to know about that. The cell phone is my only way to get that information. Another example was some of our financial institutions in their overdraft protection. You can sign up that they will notify you when you get to a certain point in your checking, let's say $20. You say, I want to be notified if I get down to $20 so I don't write a bad check. That's an automated call that comes out and says your account's at $20. Under today's law, that's not lawful, but yet it's wanted. That's our goal here. We can go through dozens of examples where people give their phone number as a contact that want the information, but it's unlawful. That's the fine line that we're writing here today, and I really look forward to Attorney General Zoller. You are particularly vociferous. I appreciate that. We want your suggestions of how to define that line, because I think all of us would say if you signed up, you want that information, you should get it lawfully. So with that, what I would like to do is yield my remaining minute 15 to the Chairman Emeritus, Mr. Barton.
I want to thank the sponsor of the bill, Mr. Terry, for yielding some time to me, even though he knows that I am in opposition to his bill. That shows great statesmanship and tolerance on your part, and I appreciate it.
Take back.
Gentlemen's time has expired.
Yeah, that's the way the game's played. I hate to be the Republican that spoils the garden party, but the current system is in place for a reason, and that reason is that people do protect and want to protect their privacy. I have a cell phone also, and the only people that have my cell phone number are other members of Congress, my family, my very close friends, and my senior staff. I know that if I get a phone call on my cell phone, it's from somebody that I know and that they need or want to talk to me. I have 3 landline phones in Texas. I know that if that phone rings, the odds are better than even that it's a commercial call that I don't really care to get. So about half the time I don't even answer it unless I'm expecting a call from somebody. I know what Mr. Terry and Mr. Towns are attempting to do, and I think it's noble, but I don't think you can draw that fine line, as Mr. Terry said. Once we open the door to automated dialing for cell phones for very reasonable reasons, such as Mr. Terry suggested, I don't see how you prevent it being used for other less reasonable reasons. So for that reason, Mr. Chairman and Mr. Vice Chairman and Mr. Towns, I do respectfully oppose the bill, but I'm glad that we're having a hearing to air the issues, and with that I yield back.
Gentleman yields back the balance of his time. Recognize the ranking member of the full committee, Mr. Waxman.
Thank you, Mr. Chairman. I appreciate your holding this hearing on the Mobile Informational Call Act of 2011. You and Mrs. Eshoo have put together another balanced panel, and it's appreciated. The Telephone Consumer Protection Act, TCPA, was signed into law by President Bush in 1991. In the 20 years since its enactment, there have been dramatic changes in phone technology. Most notably, in 1991, less than 8 million Americans subscribed to mobile phone service. Today, there are well over 300 million wireless subscribers. And every day, more Americans are cutting the cord and relying on their mobile phones exclusively. Congress enacted the TCPA based on the bipartisan premise that residential telephone subscribers consider automated or pre-recorded telephone calls, regardless of the content or the initiator of the message, to be a nuisance and an invasion of privacy. Although mobile phone usage has skyrocketed, I suspect that most Americans still have a high degree of concern about unwanted telephone calls, regardless of where they receive them. Indeed, congressional actions to protect Americans from unwanted phone solicitation have proven wildly popular. Fundamentally, we need to look at this issue from the perspective of the wireless consumer. By amending the law, as H.R. 3035 proposes, are we modifying consumer control over wireless phones? Are we changing expectations regarding privacy? Are we increasing costs? Although some consumers have unlimited texting and calling plans, millions do not. Will consumers have a clear ability to avoid unwanted calls and texts on their wireless phones when such communications increase their costs? Will consumers understand that when they turn over their wireless phone number to the auto dealership, they are agreeing to receive future auto-dialed and pre-recorded calls and texts about recalls, warranty updates, scheduled oil changes, or even from third-party bill collectors? We also need to understand and better whether existing law already allows consumers to receive calls on their wireless phones from businesses and others. Several experts have suggested that this is permissible under existing law. For example, if a school wants to use an automated dialer or pre-recorded message to call parents' cell phones or send them text messages about a snow day, this is permissible under existing law with the parent's prior express consent. Similarly, auto-dialed and pre-recorded updates from power companies, airlines, banks, and cable companies are all allowed with the prior express consent of the customers. Finally, H.R. 3035 appears to preempt a variety of existing state laws in a significant way. The bill would amend the TCPA to preempt all state laws about fax advertisements, auto-dialers, and artificial or pre-recorded voice messages. I know that preemption of state laws can sometimes be good for businesses, but it is not clear to me how preemption would help consumers or deter telemarketing abuses. I look forward to our hearing, and I wish to yield the balance of my time to Mr. Towns.
Thank you very much. I'm proud to stand with President Obama, who included this in his jobs proposal because of the opportunity it offers to assist with deficit reduction, something that we all are concerned about. I look forward to learning from the witnesses how this legislation can impact consumers' daily lives in a positive way. Again, I thank the subcommittee and my colleagues for holding this hearing. As we move forward in the legislative process, I will work with my colleagues to shape the bill to keep the important benefits bill would provide to consumers while at the same time ensuring that it has strong consumer protection to prevent and punish abuse. Critics of the bill have said that the bill will open the door to nuisance and abusive calls that impose unacceptable costs to people's cell phone bills. While I don't think the incentives are there for this to happen to consumers, I look forward to learning and hearing from the witnesses to see in terms of how we can move forward. And I'm hoping that as we move forward, some of the things that have been said, that we will be able to clear them up. And on that note, I want to thank the ranking member of the full committee for yielding to me. And on that note, I don't have anything to yield back, but I'll yield back.
Thank you, Mr. Towns. And I would ask unanimous consent to submit 29 letters in support, the majority of which are from universities so they can contact their students. So I'll submit those for the record without objection. At this time, we'd like to hear from our witnesses. We'll go from my left to right with Ms. Schwartz. You may begin, and if I could say, limit your comments to 5 minutes, and I'll lightly tap at 5 minutes so it's not being rude, just kind of notice.
Great.
Go ahead.
Thank you. Chairman Walden, Ranking Member Eshoo, Vice Chair Terry, and members of the subcommittee, thank you for the opportunity to testify today. My name is Faith Schwartz, and I'm the Executive Director of the Hope Now Alliance, a nonprofit foreclosure prevention effort, and I'm the co-founder of Hope Loan Port, which is a nonprofit web-based tool, which is a public utility for borrowers and counselors to submit loan workout packages to loan servicers for free. I've served in a leadership capacity at Hope Now since 2007, during which time I worked closely with members and partners of the Alliance, including mortgage servicers, investors, nonprofit housing counseling partners, government agencies, and regulators, to help homeowners avoid foreclosure. Before my time with Hope Now, I served in various capacities in the housing finance industry for 28 years. The comments I make today are my own and reflect my experience in the mortgage business, and in particular, working with servicers and counselors attempting to help at-risk homeowners. These comments do not necessarily reflect all the views of Hope Now. I'm here today to speak to you specifically about our ongoing foreclosure prevention efforts and the difficulties of reaching borrowers in financial distress. The financial services industry and its nonprofit and government partners remain committed to using all the tools that are available to assist homeowners. Since 2007, the mortgage industry has completed an estimated 5 million permanent loan modifications, and we know this because we measure it every month from that date based on 37 million loans. In total, the industry has provided 14 million solutions for homeowners that include loan mods, short-term solutions, such as repayment plans and forbearance, unemployment options, such as short sales and deed in lieu that provide alternatives to foreclosure. Hope Now has held 117 face-to-face events across the country since 2008. In fact, today we are in Houston, Texas, holding such an event with the United States Treasury, Making Home Affordable, and our nonprofit partners, NeighborWorks America. Without question, the outreach events have improved the experience of many customers trying to resolve their mortgage difficulties through face-to-face meeting with their loan servicer or counseling through a nonprofit agency. But our exit surveys continue to show that at least 30% of those attending had never had contact with their servicer before the meeting, despite multiple attempts from the servicer. The single greatest obstacle to keeping a delinquent borrower in their home is the inability to contact them and make aware the workout options that are available. The breadth and the complexity of options, both government programs and proprietary solutions, a full list of which I've included in my written testimony, makes it imperative that homeowners be in contact with their servicers. But we know from experience that often borrowers in financial distress do not open mail, they cancel their landline service, and increasingly rely on wireless phones as their primary or exclusive communications device. As we see these numbers ever increasing, with cell phones and text messaging becoming the primary means of communication, it has become clear that the current Telephone Consumer Protection Act, TCPA, is hindering effective communications between homeowners and loan servicers. H.R. 3035, the Mobile International Call Act of 2011, would modernize TCPA by eliminating restrictions on informational calls to mobile phones. For 20 years, the TCPA has permitted automated informational calls to be delivered to consumers' wireline phone numbers, but not their wireless numbers. H.R. 3035 would allow automated commercial calls to mobile phone numbers as long as they do not include marketing messages. Currently, our primary means of contact are landlines and mailing invitations to foreclosure or prevention outreach events. It is difficult, if not impossible, to efficiently and effectively reach approximately 40% of consumers who rely on wireless phones as their primary communication vehicle. Consumers reap significant benefits when financial institutions are able to reach them quickly and efficiently. Using the auto dialers or pre-recorded message, such as the bill allows, is not only a quicker, more cost-effective way, it would also free up loss mitigation specialists to spend time working with individual borrowers rather than making repetitive manual calls. While this bill is not a panacea, and it certainly will not end every foreclosure, it will without a doubt increase our contact rates. And the more people we contact, the more solutions we offer. The equation is very simple. If you increase the amount of customers you reach, you increase the number of workouts, and you decrease the number of foreclosures. In conclusion, Mr. Chairman, in the area of foreclosure prevention, the Mobile Informational Call Act is a positive for consumers and for those working to keep them in their homes. Thank you.
Thank you, Ms. Schwartz. Mr. Alterman.
Thank you very much. Good morning, Chairman Walden, Ranking Member Eshoo, and members of the subcommittee. My name is Steve Alterman, and I'm president of the Cargo Airline Association. We appreciate the opportunity to testify today in support of the provisions of H.R. 3035, the Mobile Informational Call Act of 2011, and we request that our written testimony be made part of the record. The Cargo Airline Association is the nationwide trade organization representing the interests of the United States all-cargo air transportation industry. That's companies such as FedEx, UPS, DHL, and all those that deliver packages. Members of our association are in the business of picking up, transporting, and delivering packages throughout the world to meet our customers' needs. At times, our members may need to notify these package recipients of scheduled deliveries or failed attempts to deliver specific packages. Typically, such notifications involve shipments where a signature is required, notifications that shipments are being held for pickup at specified locations, and COD shipments. These calls merely provide customer service and do not contain any solicitation or product marketing. In today's world, with more and more individuals relying solely on mobile phones, it is becoming even more important to permit informational calls to mobile devices. Indeed, anecdotal evidence in our industry indicates that upwards of 50% of all contact numbers provided are, in fact, cell phone numbers. Faced with these facts, the association and its member companies have a significant interest in the passage of H.R. 3035. The association supports the intent of the TCPA in that it aims to restrict unsolicited telemarketing calls to residential and cellular telephones. At the same time, we agree that the TCPA properly grants to the FCC the regulatory authority to enact limited exemptions from this general ban. It has done so to permit non-telemarketing informational calls to landline equipment, and the time has now come to expand that to cell phones. It is also important to point out that in the case of customer service calls made by the Cargo Airline Association members, phone numbers are not randomly generated or sequentially generated, but are given to the carriers by the package senders who receive them from the purchasers, presumably so they or the intended recipient can be contacted in the event that they need to be called with information about the package delivery. By giving the shipper a contact number, the recipient should be found to have authorized calls to that number, whether by the shipper or any other member of the supply chain. For example, if a customer orders an item online and provides a mobile number as the contact number, the consumer obviously consents to the retail merchant contacting them with regard to their order, as well as to other parties that facilitate the fulfillment and delivery of that order. This information exchange is purely transactional, and from the carrier perspective, the consent significantly boosts the ability to deliver packages efficiently and effectively. Finally, we believe that it's important that any legislation recognize to the extent possible that the advancing technology of the modern world. Therefore, to avoid any issues or questions in the future, we respectfully request that the proposed legislations be amended to specifically provide that text messages, in addition to phone calls, be included in the scope of the calls allowed to be made by mobile devices under the terms of H.R. 3035. In view of all these circumstances, the Association urges the enactment of H.R. 3035 to permit purely informational calls, including text messages, to mobile phones by automated recording devices. Such action will retain the intended ban on so-called telemarketing calls while authorizing informational calls that are clearly in the public interest. Thank you very much. I'd be happy to answer any questions.
Thank you, Mr. Alterman. And Ms. Ann, thank you.
Thank you. Chairman Walden, Ranking Member Eshoo, and Vice Chair Terry, and members of the subcommittee. Thank you for inviting me to testify today on the subject of H.R. 3035, the Mobile Informational Call Act of 2011. I am the Legislative Director of the National Association of Consumer Advocates. NACA is a nonprofit association of consumer advocates and attorney members who represent hundreds of thousands of consumers victimized by fraudulent, abusive, and predatory business practices. My testimony today expresses the sentiments of the 12 national consumer protection, civil rights, and privacy organizations who opposed the bill and recently submitted a letter opposing H.R. 3035 to this committee. This letter is included as an attachment to my written testimony. H.R. 3035 will allow entities to use the automatic telephone dialing system, unaffectionately known as robocalls, and automated messages on consumer cell phones under the guise of consent, even though the consumer could never have envisioned such use. Under this new bill, any transaction or relationship will constitute consent to repeatedly call the consumer cell phone in perpetuity, even if the consumer does not give out her cell phone number, and regardless of whether the consumer asks that she not be called. Imagine if after you leave today's hearing, you stop by a local pharmacy on your way home. While at the counter making your payment, you absentmindedly hand over your phone number. This transaction alone would now suffice as consent to receive a robocall on your cell phone under H.R. 3035. You've forgotten about this transaction, and a few days later, while you're out at dinner with your family, you receive a call on your cell phone with a robotic voice at the other end, thanking you for your recent purchase and verifying that the prescription you picked up is the one you actually wanted. You hang up the phone, but 2 minutes later, from a different number, the same robotic voice is on the line. You hang up again. 2 minutes later, yet from a different number, the same voice is on the line. 2 minutes later, again the same thing. You get the idea. This is the reality of thousands of Americans whose cell phone numbers have been entered into the smart dialer technology that knows when you're likely to answer the phone due to estimating when you're most available. Currently, the largest debt collectors make more than 1 million calls in one day to consumer cell phones. If H.R. 3035 becomes law in its present form, harassing robocalls on consumer cell phones will become the new norm. Today, we respectfully urge committee members to be wary of the bill proponents' motives for the following reasons. First, debt collection agencies, creditors, airlines, utilities, and other businesses may already robodial any telephone number, including cellular phones, if the number was provided to them by the consumer. Second, robocalling is also permitted in case of emergencies, such as hurricanes and other natural disasters. For example, recently, in the wake of Hurricane Irene, technologies to notify residents of emergency preparedness measures through mass notification systems were used by municipalities up and down the East Coast. Third, the proponents want to completely gut the important privacy and consumer protections found in the Telephone Consumer Protection Act. They want to strip consumers of any choice as to what phone numbers companies with which they do business may contact them. They want to remove all prohibitions against using robocalls by redefining automatic telephone dialing system to include only antiquated technology that does not exist in the real world today. In fact, under the definition provided in H.R. 3035, telemarketers, the original target of the Telephone Consumer Protection Act, would now be able to robocall consumer cell phones because most telemarketers do not use randomly or sequentially dialers. They predictably dial cell phones. They want to prevent consumers from enforcing the demands that unwanted robocalls stop and to prevent state laws and attorneys general from further restricting and enforcing laws regarding these robotic calls. In conclusion, Mr. Chairman and Ranking Member, I urge this subcommittee not to open Pandora's box of the many unforeseen harmful consequences that will result if H.R. 3035 becomes law in its present form. Thank you.
Attorney General Zoller.
Thank you, Mr. Chairman and members. I appreciate Congressman Terry pointing me out as having spoken out on this in the newspaper. It recognizes that it's very important to the state of Indiana and the people I represent. I think particularly our focus of concern on H.R. 3035 deals with the proposed areas that deal with preemption. And preemption is one of those words that gets the attention of attorneys general. Just in the last day, I've received contact from the Attorney General's office in Connecticut, Iowa, Illinois, Kentucky, North Carolina, North Dakota, Nevada, Oregon, and Tennessee, immediately upon learning that I was coming here. So I recommend to all the members to please contact your attorneys general in your home states and kind of listen to the boots on the ground that have to represent the consumers of your state. Over the last 20 years, Indiana has had a very unique experience under our own sense of privacy among Hoosiers. We had an auto dialer statute that prevented the use of the technology since 1988, well before it was seen as a problem. We had a do not call statute in 2001 that does not allow the exemption of prior business relationships. So unlike the experience of the congressman from Texas who says he won't answer the home phone, in Indiana you can still answer your phone because it will not be a telemarketer. We had a do not fax statute in 2006. In this past legislative session, we allowed for cell phones to be added specifically to our do not call list. We now have over 2 million lines registered on our do not call statute. This past session, after the General Assembly allowed the cell phones, we had 189,000 immediately within a very short period sign up for the do not call my cell phone. So the auto dialer law is particularly one where we have the biggest problem. In Indiana, if you get a robocall, it's a scam, and everybody knows it's a scam because it's prohibited. It's the one state where if you ask the members of Congress, your colleagues from Indiana, where they do not use robocalling even for the teletown halls. So it recognizes that in Indiana we have a certain appreciation for privacy that may not be common in all 50 states. They're subject to the federal do not call statute that allows for the exemption of the prior business relationship, which I think has desensitized a lot of people, or as your colleague from Texas just simply doesn't answer the phone. So due to the success of our laws, the people of Indiana have been very sensitive to this, and quite frankly, when I've toured the state talking about my trip out here, I heard very specifically some of their passion on this issue. Another point that I would make is that in 2010, recognizing that there's questions about political free speech, I asked the 3 major parties in Indiana to a treaty of 2010 where they all agreed not to use or encourage the use of telemarketing, and I can report that that treaty was not broken during the 2010 election cycle. If you look at the history of the federal statute, starting in 34, it was really meant to focus on the services and facilities and not really the use in the states. So one of the things that we're asking, and it's not that big an ask, having recently had a federal court preempt the use of our own state statutes prohibiting auto dialing, I would like to ask the committee to take a hard look at the use of the word intrastate, which was exactly what the court found allowed for the preemption of things that were interstate. So again, having recognized the problems of this case that we submitted in our written testimony, I would ask your staff to take a good hard look at that case where 2 weeks ago Indiana's robocall statute has now been preempted by the very act of Congress that I see again here in front of us. So I would grant back the 5 seconds that I've got left.
That is appreciated. Mr. Altschul.
Good morning, and thank you, Mr. Terry, Ranking Member Eshoo, and members of the subcommittee. On behalf of CTIA, I thank you for the opportunity to participate in this morning's hearing. CTIA was here and proud to support the original TCPA 20 years ago, and we welcome the introduction of this bill, H.R. 3035, as we believe it helps illustrate how profoundly the wireless industry has changed over the past 20 years. A number of you in your statements have talked about the phenomenal growth and acceptance of wireless. I thought for show and tell, I'd bring the state-of-the-art phone from 1992. And 1 month after the TCPA was passed into law, Motorola's MicroTac Lite was introduced to the public in January. It was claimed to be the first phone that you could fit into your pocket, required quite a pocket, and cost as much as $2,500. And by the way, service prices in 1992 on a per-minute basis were 10 times higher than they are today. So obviously over the past 20 years, there's been phenomenal change and growth in the industry and Americans' acceptance of wireless. We've gone, as you know, from 7 million to over 300 million subscribers, and we're proud as an industry that America now leads the world in delivering next-generation wireless services at a lower price per minute of use than in any other country in the developed world. For the purposes of today's hearing, it's perhaps this point how wireless has been adopted as the primary source of communications for millions of Americans that may justify a fresh look at the TCPA restrictions on the delivery of informational calls to mobile devices and the challenge we all face in crafting a law that will permit wanted commercial communications while preventing unwanted communications. Others have noted how more than 25% of Americans have cut the cord. Some locations, the numbers are substantially higher, and as high as 40%. Obviously, this shift creates challenges for companies and government agencies that want to provide informational calls to individuals who are not reachable in any other way and may value timely notifications of the kinds of alerts and information that others on the panel have described. I want to focus the remainder of my time on 3 issues of unique importance to the wireless industry. First, and it's a personal peeve of mine, along with customers, wireless carriers are victimized by violations of the TCPA by unscrupulous boiler room operators seeking to sell extended car warranties and the like. In cases where they can locate and identify the source of these messages, wireless carriers have vigorously brought suit to shut down these scams, and we're proud that we have cooperated with state attorney generals and the Federal Trade Commission in investigating and prosecuting TCPA cases. Unfortunately, while we do all we can to identify and shut down TCPA violations, the FCC continues to catalog TCPA reports as wireless complaints. We believe it's unfair for the Commission to count these complaints, which originate outside the wireless network and have nothing to do with wireless carriers' conduct and behavior, as wireless complaints in their quarterly reports. And for this reason, we urge the subcommittee to compel the FCC to disaggregate TCPA data from reporting wireless complaints. Second, the FCC has an open proceeding in which it has sought comment on proposals to harmonize its TCPA rules with the FTC's telemarketing sales rules. In this proceeding, we're concerned that requiring wireless carriers to obtain their customers' express written consent to receive auto-dialed or pre-recorded non-marketing calls could overturn the Commission's precedent permitting wireless carriers to send free to the end user calls and messages to their customers without additional consent. As you may know, the industry has recently committed to deliver usage notifications to wireless users when they near plan thresholds to prevent bill shock and overage or international roaming charges, and we don't want anything to interfere with our ability to do that. Third and finally, there have been a series of class action lawsuits filed against Twitter, Facebook, banks including Barclays and American Express that threaten the industry's efforts to protect privacy and comply with the Mobile Marketing Association's consumer best practices. These suits allege that the best practice of sending a text message to confirm receipt and acceptance of a customer's request to quit or stop violates the TCPA. It's unreasonable, and it's another matter we'd like this committee to look into. So thank you for your consideration of these suggestions.
Thank you for your testimony, and all of you for your testimony. At this time, we're going to begin our questions. Attorney General Zoller, I'm going to start with you, and this is friendly, but I am concerned about state preemption too. So what I would like to ask you is if you would help us work with language that would make states feel comfortable that we're not preempting your individual state laws. I want to point out the flip side and why we need to work together on this. One is, as I understand, one of the laws in Indiana specifically allows auto-dialed calls from schools. Well, the FCC, if that school is texting about a snow day, whether it's a university or just a public school, may be in violation with an auto dialer, subject to, as Mr. Alstead said, $500 fine per student. So we have to work that. I wanted to point that out. Would you be able to help us draft some language that would protect Indiana and state's laws, at the same time making sure that when they comply with the state law, they're not in violation of federal rules and regulations?
Absolutely. No, we have no concerns about how the rest of the country and the federal government regulates. It's our experience, though, and I think if it sounds like I've got reservations about the promises, that we were here representing the state of Indiana when the TCPA was enacted, and there was assurances that there would be no preemption. And 2 weeks ago, a federal court struck down Indiana statute on preemption grounds. So we would be very willing to work with the committee.
Good.
But recognize that we worked last time, and the same people who've supported this bill have been attacking our statutes for the last decade until they finally preempted our statute.
Okay. So Ms. Hand, you raised some concerns, and frankly, just like Ranking Member Eshu's constituent did, and some reporters as well, that this is opening up the Pandora's box. And in your comments, you said that our intent was to cause that. And I just want to place on the record, we worked with ledge staff specifically saying, let's draft language that prohibits the unsolicited marketing, teleservices, random calls like you were talking about. That truly, we worked hard to make sure that wasn't true. So I got to tell you, I took a little offense when you said that was my intent in drafting this. It is completely the opposite. So you have a concern. Ms. Eshu has a concern. I've heard concerns from people back home when they read about this bill, about getting the unwanted telemarketing. Will you work with me to develop language so that we can have language that's clear, that bans or continues to ban? I still think our language still bans those type of calls. Would you work with us on that?
Certainly. We want to be a part of the conversation, and we want to work with you to ensure that consumers are continued to be protected. So we appreciate you extending that.
Okay. We want to make sure that our intent here is that people, when they want information, are able to receive that without the sender being subject to lawsuits and fines, and continue to ban unwanted calls. So I appreciate your willingness to work with us on it. At this time, I'm going to yield back my time and recognize the ranking member. I've got a little cold going on here, and Eshu, and it's Friday.
Thank you, Mr. Chairman, and thank you again to the panel. I think it's the collective testimony has been instructive, and I thank you for it. To Attorney General Zoller, it's an honor to have an AG here. The TCPA sets a floor and not a ceiling, allowing states to experiment and give consumers more protections should they wish to do so. And I think that you've spoken very clearly about the wishes of your constituents and the actions that your state has taken, and I salute you for that. Now, by contrast, this bill would take away the state's ability to provide additional protections to your consumers by prohibiting any state laws addressing the subject matters regulated in the bill. Is that your view of it?
Well, the particular concern is the use of the word intrastate, which is exactly how in the lawsuit.
And you've said that in your testimony.
The fact that it says intrastate has been read by the federal courts to allow the argument that we're preempted on interstate. So it really, I heard the floor and not the ceiling, but when we're preempted, so it was the floor and the ceiling.
Thank you. And to Ms. Hand, as currently written, I understand that this bill would narrow the TCPA's definition of an automatic telephone dialing system. And based on your reading of the bill, wouldn't this create a loophole that enables live telemarketing calls?
Yes, this is correct. As currently defined in the bill proposes to define automatic telephone dialing systems as machines that randomly or sequentially generate telephone numbers. And so what this would do in effect is that the industry standard for dialers would not be included. It would exclude what is known as predictive dialers, which are predominantly used by telemarketers and debt collectors. So it would, in effect, reverse the original intent of the Telephone Consumer Protection Act. So it's very concerning.
And I think that this is a closely held value that came out of the TPCA legislation. So I think that's where an awful lot of upset is coming from. Ms. Schwartz, thank you for your testimony. As I noted in my opening statement, a prior express consent, those are really important words. They have an important meaning to consumers. If you have the express consent to reach a customer's mobile phone, what prevents you from delivering them these important informational messages today under existing law?
Yeah, I think you're right about the prior. Pardon my voice, I woke up without one this morning. Nothing prevents you when you have prior consent. Sometimes these are new accounts, and then people have changed behavior, and they've closed down their landlines. So my whole focus is reaching people, sharing information that's pertinent to them keeping their homes, and engaging with them when they have been reluctant to do so or want to do so but have not been effective. So on both sides.
But what prevents you from doing that today under existing law, what you're describing, what you want to do with the, the work of your organization?
Well, we go to landlines and we go to mail to get to borrowers, but we don't go to cell phones because because we don't have that prior consent or it's thought to violate it. So.
I wanted to ask a question of the chairman. Is the Association of Credit and Collection Professionals supporting the bill? Does anyone know?
I didn't look at the 29 letters there.
To Mr. Alschull from the Wireless Association, thank you. And I think that it's wonderful that you brought the old set and talked about the changes that have taken place. It's nothing short of stunning, the changes that have taken place in a short period of time. You noted that prices on a per-minute basis were 10 times higher in 1991 than they are today, but text messaging is one feature that didn't exist 20 years ago. Would you agree that it's fairly common for consumers to pay on a per-message basis? And what's the average cost of receiving such a message today?
I don't know that information. Be happy to provide it. I know that there was a hearing about 2 years ago, and a couple of our member carriers did provide information to Congress. The overwhelming majority, if I recall their testimony correctly, the overwhelming majority of customers do have some kind of bucket of texts, but there still are customers like my mother who don't and would have an a la carte charge for receiving a text message.
Okay. Thank you, Mr.
Thank
Chairman.
you.
I yield back.
Mr. Stearns, you're recognized.
Thank you, Mr. Chairman. I was the author of the Do Not Call list when I was chairman of the Commerce and Consumer Protection. At that point, it was trade, and then once we passed that, then we had to in the next session of Congress pass another law to make sure it extended. And I found it's the most popular bill I've ever passed, and it's perhaps one of the most popular bills that's ever passed Congress because everybody was just lauding it. So I think when we move into this, we've got to understand some of the nuances between the land lease lines and the cell phone. So let me just go across the panel and ask this question, yes or no. I think many of us don't want to allow intrusive telemarketing calls to consumers any more than many of you do too, and we just want to make sure that you don't have your cell phone being answered time and time again with a computerized call telemarketing. Do you think there are ways we can clarify that auto dialers and pre-recorded voice messages should not be used to make telemarketing calls to consumers? Ms. Schwartz?
Yes, we would support that clarification that you should not be subject to telemarketing calls.
So you think we can clarify and make that okay, Mr. Alterman? Yeah, yes.
Absolutely, I agree.
Okay, Ms. Hand?
Well, I think while there might be some clarifications that can be made, I'd like to reiterate that current law currently allows contact with the consumer, and there's a very bright line here with respect to consent.
So technically, you think between auto dialers and pre-recorded voice message, we can make a clarification so that these don't end up being telemarketing calls? You think we can do that?
Yes, we can do that, but consumer consent should absolutely be preserved.
And how would we do that?
Well, I'm happy to continue working with staff to work out the technical languages, but we just want to make sure that consumers have an absolute ability to opt out of receiving any pre-recorded or...
Like calling the Federal Trade Commission on a toll-free number and saying, I don't want to...
I'm sorry, I can't.
They could call the Federal Trade Commission and ask them to make sure that my number is not included in that. Is that one suggestion?
Potentially. I mean, we'd have to think about it, and
okay, go ahead, Mrs.
I'm happy to work with staff.
Yeah, your comment?
I think the key would be as long as states were allowed to have additional restrictions.
Okay.
Prohibition on telemarketing calls has worked well and is broadly supported.
Okay. Ms. Hand, your testimony suggests that current law empowers a consumer to demand that incessant calls stop and that the proposed legislation removes that protection. Can you point to me specifically to where that protection exists today for, say, landline calls, and what provision specifically eliminates that protection?
Well, it's actually what's not included in the bill, and so I refer to an FCC ruling, a 2008 ruling by the FCC in January of 2008, where the FCC recognizes, and the specific language, if I may just point to it, the FCC recognizes the right of consumers to request calls to stop. And so the FCC in the 2008 ruling said that absent instructions to the company, persons who knowingly release their phone numbers have in effect given an invitation or permission to be called. So in other words, consumers have the right to ask to stop receiving calls. The bill doesn't address that, and so in essence, there is no enforcement mechanism. If a consumer were to receive a robocall, they could ask to stop, but there currently would be no enforcement mechanism to stop those calls under the current language of H.R. 3035.
Will the gentleman yield for 1 minute?
Sure, glad to.
Yeah, that's a great point that you bring up, and Ms. Hand, you bring up, and Mr. Markey's brought it up, and that's one of the areas that we're willing to work on.
Thank you.
Ms. Hand, another question. Do you agree that consumers benefit from the informational calls discussed by Mr. Schwartz and Mr. Alterman, and how can the proposed legislation be modified to allow such calls without opening the door to harassing? And I think you've touched on that. But Mr. Alterman and Ms. Schwartz, do you agree with what Mrs. Hand is saying in this area of changing the legislation?
I think abusive and repetitive calls should not be permitted, just as they're already under protection on the FDCPA. But I think it's very important to be allowed, if you already have a business relationship, to alert people of opportunities to fix their loan before they go to foreclosure by a cell phone.
Okay. Mr. Alterman?
Yeah, Let me make one thing perfectly clear. We do not want to make repetitive calls, and we would absolutely have no problem with language that would do that. I would like to make one comment, because a comment was made earlier that airlines already have the ability to notify people by this, and our industry, unfortunately, is one step removed. The phone calls that are the phone numbers that are given to retailers such as LL Bean. That we get the phone numbers from them as part of the same transaction, but it is unclear. I could with a straight face argue that constitutes consent, but it's unclear, and this bill would make it clear that we would like this bill to make it clear that that's all we want to do. We just want to tell someone there's a package ready.
Thank you. Mr. Doyle.
Thank you, Mr. Chairman. As I said in my opening remarks, I think the bill is well-intentioned, but obviously I think we have a lot of work to do here. As I read this bill, if a person provides their phone number as a means of contact at any point during a business relationship with a company, then that constitutes prior express consent. I just bought a washer and dryer 2 weeks ago at an appliance store, and they wanted to give me like a 40-minute notice before they were going to arrive at my house so that somebody would be there. And they asked me for my phone number, and I gave it to them. Now, I don't ever want to hear from that appliance store anymore if they've got TVs on sale or computers or what, and I certainly don't want to start getting text messages from that company. So I guess what I want to ask Ms. Schwartz and Mr. Alderman and Mr. Alsha is why do you think the mere giving of a phone number in a business relationship, you know, like the example I've just cited, why do you think that should imply that I want to hear from those companies in the future?
Well, sir, that's an interesting analogy. I look at this completely from the mortgage experience. When you take out a 30-year mortgage and have a relationship with your bank or loan servicer, you should figure out the effective ways to communicate with each other. And if you don't have a landline and you don't communicate, you will go to foreclosure if you're not making your payments and you don't have an opportunity to talk to your counterparty to understand all the options available to avoid that.
But isn't it as simple as, you know, people want to know how can we do this? It's simple. Ask. I mean, why don't you just, I mean, right now, TCPA and FCC rules allow people to say up front, I want you to be able to contact me. And so it seems to me that, you know, your constituencies, whatever, you know, the mortgage business and whatever, you should just ask the consumer when you have that first contact with them, will you give us permission or do you give us permission to contact you if we have some information about our products or our services, and the person says, yes, I give you my permission, and I think that solves the problem. Just ask the consumer if they want to hear from people, and if the consumer say yes, case closed. But I got to tell you, and I especially worry about young people. Now, my kids, they can't afford these high bundled plans, Mr. Altshup, so they have these prepaid phones, and they don't talk on the phone anymore. If I want to talk to one of my kids, I have to text them or they don't answer me back. Okay, I can't send emails or call their phone numbers. They just don't respond. But I know the plans. It's like you got so many texts you're allowed for one price, and then it goes, you know, because we end up paying every time they go over their text messages and they call crying to us that they don't have the money to pay their phone bill. The industry's already voluntarily said, you know, they're going to start notifying people when they're getting close to using up their plans so that they don't have this sticker shock, you know, when their bill comes. I mean, imagine...
We've done that on a free-to-the-end-user basis, by the way, so this won't generate a usage call.
Exactly, but imagine the calls you're going to start to get when these young kids start to get these text messages from these telemarketers that they don't want, and it starts to run their bill up either over their prepaid pay, and they're going to be calling your companies complaining, you know, that they owe all this money for calls that they don't want to accept. So, I mean, Lee, I think this is simple. I think we just ask consumers if they want to hear from these folks, and if they indicate they do. I know when I go online and order a product, there's always a box there that says, would you like to hear from us on any future sales our company has? And I get to check the box, and then I get emails from that company.
1 o'clock today?
Pardon me? Yeah, but I'm saying, you know, to me, I think it's pretty straightforward. Just ask people if they want to hear from you, and if they say yes, then they want to hear from you. If they say no, they don't want to hear from you, and don't call them. And I think that
we would appreciate working with you.
May I follow up with that, sir?
Yeah, sure. I've got 40 seconds.
But my only point is, when you buy a house 4 or 5 years earlier and your life changes and you are not in contact, and there are millions of people who are not in contact on their home loan today who are in trouble. And so any effective tool to reach them and have an effective conversation and invite them to participate is a meaningful way to work.
And I think if you would say to that consumer when they buy the house, if there's a situation where we could provide different options for you if you have financial trouble, would you like us to be able to tell you what those things are? People can make that choice. Thank you, Mr. Chairman.
Mr. Chairman.
Well, thank you, Mr. Chairman. I appreciate your chairing this hearing and bringing this issue to our attention. Obviously, there are a lot of views on how you might get this done. And I know it's not your intent to open the door to random telemarketing calls. That's not what this is about. I have found it interesting, though, and I've been in the back in some meetings, but also trying to keep an ear to the testimony, that there does seem to be this persistent issue about the way technology has changed. There are now more cell phones than there are citizens of this country in use in this country. People are cutting their landlines, and there are some legacy rules here. Now, I don't want random text messages from companies just to market to me. I don't want random cell phone calls. But I did note when our colleague from Tennessee talked about just the nature of FedEx being able to automate the call that says we're going to deliver the package to your house. I've encountered that where they call our landline, but nobody's at home. And so you get the call later, and they couldn't leave the package, so now I got to call them, trace them down, figure out where to go get it, and go through this drill. If there were a way that they could have just called my cell phone, then I'd know, okay, I can run back to the house, whatever, this is my home life. And so I'm trying to figure out, is there a way to thread this needle that we don't open this door that I don't know anybody on this committee wants to open on sort of random telemarketing calls to cell phones, but that allows that understanding how technology's changed. Because if I understand this right, if there's a human dialing the number, that's okay. But if I pull it up on a computer screen and push a button, that's not okay. Now, I got to tell you, and I realize it's probably the race between gray and gone and loss of memory, but I have trouble remembering people's phone numbers anymore because I pull out one of these devices, and right here are my favorite phone numbers of my friends, family, or staff, and I just push, you know, Brian or Ray or whomever, and it dials it automatically. Now, with that kind of is that an automatic dialer? It's not. Some of you say it's not. Some say it is, right? Okay, well, somewhere, though, if I had to reach 30 people, I might have a system, and it'd basically say, call Bill, Ed, Ray, whoever's available, and I'll talk to the first one you find. Is that the auto dialer we're talking about here? So it's just, if they're all my friends or whatever, I don't know. So I think there's a way to get at modernizing the law without opening the door to unwanted solicitations and informational calls and all that stuff. So anyway, I would yield to the chairman.
All right, thank you. And I do think you hit on probably the ultimate point here is we focused on the technology change from wire lines to wireless, but the reality is the trap we're in is the technology of an operator dialing versus manually dialing versus clicking and having a computer program that would automatically dial, like the school notices or all of that. So that's the technology that's hanging up the TCPA right now and is the good and the bad, and we've got to figure out how to draw that line. So I appreciate that. At this point, Mr. Markey.
I thank the gentleman very much. So I am the House author of the Telephone Consumer Protection Act of 1991, which is amended by this act. And I feel as strongly today as I did 20 years ago that consumers should not be subject to intrusive calls from telemarketers, whether they are at home or on their mobile phones. So we were looking at that time about people who had just ticked off that they were getting called just every night, just around dinner time. Just an amazing coincidence that they didn't call at 2 in the afternoon or 11 in the morning, but it's always just as people are sitting down to dinner, when parents were reading to their kids, when people were trying to unwind from a long day, and that's when everyone just started to call and the phone would just start ringing. So we banned auto dialing and pre-recorded calls to landlines and mobile phones with certain exceptions, and we established the do not call list, the law creating a zone of privacy that remains hugely popular with consumers to this day. So here's my question. Maybe Ms. Hand or Attorney General, maybe you could help me with this. So under this, as we discuss this, if, let's just say members of Congress get home late from wherever they go, okay, and they just start calling whatever their local takeout taxi is, and one day they're calling to have Italian food sent over, another day they're Chinese, Ethiopian. Well, let's just say by the end of the year they've called 20 different restaurants to have takeout taxi, bring it over, pizza, whatever. Now, under this proposed change, what would the relationship now be between those 20 restaurants and you at home in terms of their ability to call you with the good news that the poo-poo platter is now on sale, or the new egg parmesan, and would that now make it possible for them to call you with all the great news that each one of the 20 have, even though you wanted a one-time relationship with them on the cheese pizza or the Chinese or other foods? So help me with that. What happens under this proposed change in terms of my relationship with the restaurants in the greater Boston area?
Well, Mr. Markey, you raise a really good point. Under the language of the bill as it currently is, this would now qualify as an established business relationship.
That's an established, that one-time call for?
That one time. You've called, you've made a purchase, and you've provided contact information. This would suffice to be an established business relationship for the purpose of receiving robocalls on your cell phone.
So is that correct?
Yes, and what I would like to point out is in Indiana, we did not include a prior business relationship exemption. So in Indiana, you would not continue to get any other calls. They don't have a prior business relationship exemption, so you don't get, when you're listed on our do not call, you don't get calls.
Would that be a nightmare situation for families where every night they get a call in a different language, letting you know that your favorite
food in Indiana, if you would have not allowed for that prior business relationship exemption in the original act, you would have been much more popular than you are today.
Yeah, yeah. So if you give over your phone number, so now it's just your phone number, is handed over to someone just to even get information. Now, under this proposed change, would just handing over your phone number now create a pre-existing business relationship for all purposes, even though you might not have even purchased something?
Well, under the federal statute. But again, as long as we're not preempted, it would not create, because we don't have the exemption in Indiana. If you preempt us, though, and we have to follow the federal model, Indiana would get the 12 on average calls per week that most people in the country do that have a federal do not call, but not a tough law like we have in Indiana.
So, what is your answer to that, Ms. Schwartz? How do we protect it? You want mortgage information because they're the individual's largest single, investment in their lives could be at stake. Well, but you hear all the other stuff that could now happen coming in under that exemption. So what would you do to protect against the tsunami of calls that would inundate people's cell phones, and people would have to pay for the right to have the text or have the cell phone coming into them because it's on their bill?
Oh, I'm certainly not an expert on the breadth of the complex legal side of this, although it sounds like telemarketing to me. And I thought that was explicitly not, that there was a protection against that in this bill. So I would thread the needle a little more closely to make sure that doesn't happen.
Thank you, Mr. Markey.
Okay, so, okay, that's great. Now, could I be recognized on my own time? I've been using...
Reserving the right to object.
All right, I'll wait.
Why don't we come back?
I'll wait for my turn to come back.
Mr. Shimkus.
Thank you, Mr. Chairman. This has been a good panel and a great discussion because I think you can see where we're all trying to wrestle with this. Everyone has stories. I'm from rural America. Propane is the heating fuel of choice. I have a constituent who dropped the landline. And the system was with the propane industry that when you would go low on propane, they would then dial you and say, hey, you're running low, you better fill up your propane. But since they dropped the landline, they couldn't get notified. And so in the middle of the night, they ran out of propane, and that was not a good time to run out of propane in the middle of the night in mid-December. So this is I think we're talking about making consent easier, where we understand the business relationship more defined, so that as Michael Doyle said, and I'm glad he finally got a washer and a dryer. I've been hoping he'd buy one for the last 10 years here. So, but as he said, we want to make sure we establish a business if there's a business relationship and they opt in, say we want to continue to have this communication, then we need to have this. These constituents of mine want the propane company to be able to call them on their cell phone if the propane is running low. And so that's what this is about. I've got two questions, but I want to go to the Attorney General first, because his story in the either an answer to a question or is really encompassing of kind of our debate here in Washington. And correct, maybe you want to restate it. You said you were pretty well promised that the state of Illinois would have been left alone in your ability to deal with this. However, the courts got involved. Is that right? Can you explain that real quickly again?
Well, the case of I think the telemarketing companies had a client named the Patriotic Veterans Association, and they were wanting to have blast out these robocalls to literally hundreds of thousands of people in Indiana because they had their numbers. They had given money to various charities over the years. They wanted to blast out these pre-recorded phone calls. And the court, looking at the language of the TCPA, recognized that just as this bill does, says that it's not to be preempted for intrastate. Therefore, since they did not mention interstate, if they choose to use robocalling equipment outside of our domestic robocallers in Indiana, they're free to do so because the federal government, although well-intended by Mr. Markey and others, had opened up the door to preemption.
Right.
So after a decade of fighting us, they finally got a federal judge to preempt our enforcement of our own statute.
And that is a continual debate we have about here, the unintended consequences, going to the court and then changing the intent of the law, and then we have to come back and refine it. And I just, that's a good thing to have on record on other issues that we debate here in Washington, D.C., and I enjoyed that. I will use that example in the future. Ms. Hand, Indiana's law allows auto-dialed calls from schools to parents and does not distinguish between calls to landlines and calls to cell phones. Do you think Indiana's law is unreasonable?
Absolutely not. I think if the state legislature determines what's appropriate for its residents, that should hold, and the state's law should not be preempted.
Yeah, and my time is running, and we got votes. So, Mr. Altman, talk about the benefit of text messaging, and I have young kids still. Texting is a communication mode now. It was emails, it was phones, now it's texting. So talk about the importance of text messages.
I think that it's just, as things develop, as technology develops and the way our society develops, it's becoming a more basic way of communicating. And some people like phones, some people like text messages. Text messages are a little less intrusive sometimes because nothing rings, and you can answer them whenever. So it's becoming more of a way of contacting people.
Although I think I woke up my son at 5 a.m. this morning because it vibrated. And these kids sleep with their phones these days. So anyway, thank you very much. I yield back, Mr. Chairman.
Thank you, Mr. Shimkus. And we do have votes on the floor, which is, timing is perfect. Mr. Barrow, I recognize Mr. Markey, so
I think
it's Mr. Barrow's.
No, I think the chair. So I guess what we all want and is kind of some common sense rule here that doesn't have your phone ringing all night long, huh?
Agreed.
And if looking back 20 years and all the changes that have taken place, we might want to, tweak it here or there. That's one thing. But I think people love the peace and quiet of their home. And I also think that when you're talking about people's new, devices, since they have to pay for the right to have all of these, communications, and it is a little bit of a safety zone for people right now. That is that the only people who know your cell phone number are the people you give it to. It's not in the phone book. It's not, for everyone to know. And you can walk around not thinking that you're back at home, that this phone is going off 40 or 50 times because it's just some kind of public, phone booth. So I think if we can, work together to accomplish, the kind of the limited goals that people might have, but not to open this thing wide open, but still to preserve for the Attorney General and others the right to be able to give Hoosiers a little bit of additional protection if they would want to do so because of the independent nature of that state. That they just might want to give a little bit more protection to their consumers, and that's
those are all things we would agree with. I would agree with.
Beautiful.
So let's work together. Appreciate that, Mr. Markey. And Mr. Barrow, do you have any questions? Yeah, twice. So thank you all. I think it's been a very productive hearing and gives us a path forward with your advice and counsel. So at this time, we are now adjourned.